The Constitution of the United States of America. The United States Constitution, which was the joint idea of America's greatest leaders after the Colonies War for independence, has been protecting the rights and freedoms of Americans since its adoption on June 21, 1788. This document also inspired many patriots from around the world who wanted to establish a wise and just government, which was the goal of this work set by George Mason for the framers of the Constitution at the Constitutional Convention in 1787. For readers interested in this historical document and its connection with contemporary democratic governments, this publication reflects the entire text of the Constitution, the Bill of Rights, and the constitutional amendments adopted from the first 10 amendments onwards. It also describes the historical developments that led to the convening of the Constitutional Convention, the discussions and compromises among the delegates, and the process of ratification and amendment. Finally, it also reflects the explanations of the Constitution and the 27 amendments. One country. Single Constitution. One destiny. USA Senate Member Daniel Webster. March 15, 1837. The United States Constitution establishes the fundamental laws of the nation. It establishes the form of the national government and defines the rights and freedoms of the American people. The Constitution also enumerates the purposes of the government and the methods by which it achieves those purposes. Previously, the leaders of the country were confederate in accordance with their articles. They formed an alliance among the states. However, the Congress established under these articles lacked the authority to ensure that the states worked together in solving national problems. After winning the War of Independence, 1775 to 1783, the states faced the problems of peacetime governments. The states had to enforce law and order, collect taxes, pay off a large public debt, and regulate trade among themselves. They also had to deal with Native American tribes and negotiate with other governments. Prominent statesmen such as George Washington and Alexander Hamilton began talking about the establishment of a strong national government under a new constitution. Hamilton helped convene a constitutional convention in Philadelphia in 1787 to review the Articles of Confederation. But most of the delegates at the convention decided that a new plan of government should be drafted instead, the United States Constitution. The Constitution created not only a union of states but a government with direct authority over all citizens. The Constitution also clearly defines the powers of the national government. In addition, it ensures that the rights of the states and each individual are protected. The supreme law of the land. Constitution. It consists of the preamble, 7 articles, and 27 amendments to the law. It establishes a federal system by dividing authority between national and state governments. It also creates a balanced national government by dividing power among 3 independent branches: the executive, the legislature, and the judiciary. The executive branch, the president, enforces national laws. The legislative body, the Congress, makes laws, and the Supreme Court and other federal courts decide cases pending in federal courts by interpreting and applying the law. Federal powers listed in the Constitution include the right to collect taxes, declare war, and regulate interstate and foreign commerce. In addition to these delegated or expressed powers, explicitly enumerated in the Constitution, there are also implied powers of the national government, not expressly granted but logically entailed by delegated powers. These implied powers ensure that the government can meet the changing needs of the country. For example, Congress has no authority to issue paper money. But such power is implicit in the power to borrow money and mint coins. In some cases, the national and state governments have parallel powers. In other words, both levels of government can make decisions. In case of a dispute, the national government has final authority. There are also some powers that the Constitution does not grant to the national government or prohibit to the states. These reserved powers belong to the people or the states. The states' powers include making laws regarding divorce, marriage, and free public schools. Powers reserved for the people include the right to own property and the right to a trial by jury. The Supreme Court has the final authority to interpret the Constitution. The Supreme Court can strike down a law, federal, state, or local, that conflicts with any part of the Constitution. The need for a constitution. The government created by the Articles of Confederation was not strong enough to govern the new country. For example, it lacked an executive branch and a system of national courts. It could not regulate trade between states or collect taxes from states and their citizens. This was little more than an assembly of representatives from 13 independent states. In 1783, after the War of Independence, the country entered a period of instability in the economy and political situation. Had conditions been better, Alexander Hamilton and his supporters would not have had much of a chance in their campaign for a new constitution. Some historians may have painted the troubles of the new republic in too gloomy colors. But there is little doubt that the situation became increasingly worse after 1783. Each state acted as if it were an independent country. Each conducted his own affairs as he saw fit, with little regard for the needs of the republic. A dozen separate coins were in use in the provinces, most of them completely worthless. Neighboring states were collecting taxes on goods imported from each other. Great Britain refused to reopen trade channels essential to the economic prosperity of the colonies. State legislatures refused to pay the debts they had incurred during the Revolutionary War. Many states have passed laws that relieve debtors of their obligations. Worst of all, some people began to consider taking up arms again to solve their problems. In 1786, in western Massachusetts, thousands of farmers under the command of Captain Daniel Shays rebelled against the state government in Boston. State soldiers eventually suppressed Shays' uprising. George Washington and other leaders began to consider whether the colonies' rebellion against Great Britain was futile. They felt that it was time to put an end to these disturbances and restore peace and order by establishing a new national government. This new government had to be strong enough to be heard within the country and respected outside the country. Representatives from 5 states gathered in Annapolis, Maryland, in 1786. These representatives proposed that a commission be formed to review the Articles of Confederation, to meet in Philadelphia, and that the states appoint members to this commission. Congress accepted the proposal and proposed that each state elect delegates to the Constitutional Convention. Constitutional Convention. The convention was expected to meet on May 14, 1787. However, only a few of the 55 delegates had arrived in Philadelphia by that date. The convention finally officially started at Independence Hall on May 25. 12 states responded positively to the convention invitation. Not wanting the national government to interfere in its affairs, Rhode Island refused to send delegates. 39 of 55 delegates signed the United States Constitution on September 17, 1787. One of the signers was Delaware delegate John Dickinson, who left the meeting but asked another delegate George Read to sign on his behalf. Convention Secretary William Jackson witnessed the signings. Among the delegates were some of the most experienced and patriotic people of the new republic. George Washington presided over the convention. Benjamin Franklin, 81, attended as a representative from Pennsylvania. Alexander Hamilton, a very intelligent person, represented New York. Virginia Representative James Madison received the title of Father of the Constitution with his speeches, negotiations, and reconciliation initiatives. Madison told the delegates that they were discussing a plan that would determine the fate of the Republican government for all eternity. Keep a record of the discussions held by delegates and the decisions taken. Other people who contributed greatly to the writing of the new Constitution include John Dickinson, Gouverneur Morris, Edmund Randolph, Roger There Was Sherman, James Wilson, and George Wythe. Morris, Madison and he was perhaps the most influential delegate after Washington. Morris was given the task of finalizing all motions and decisions of the convention. Morris was the person who actually wrote the Constitution. An original copy of the document is kept in the National Archives building in Washington, D.C. A few leading figures of the time did not attend the convention. John Adams and Thomas Jefferson served on various missions abroad on behalf of the government. Samuel Adams and John Jay were not able to become delegates from their own states. Patrick Henry refused to attend the meeting after being appointed as representative because of his opposition to giving more power to the national government. 3 leading members of the convention, Elbridge Gerry, George Mason, and Edmund Randolph, refused to sign the Constitution because they opposed parts of it. Background of the Constitution. Delegates to the Constitutional Convention voted for a new one working to create management. They relied heavily on past experience. They recalled many important events in the development of constitutional government. These included the passage of the Magna Carta, an English constitutional document, in 1215 and the convening of the Jamestown Representative Assembly in 1619. Some of the American colonies also became examples of constitutional government. They had their flaws, but they were more advanced than other governments of the time in providing freedom under the law. During the Revolutionary War years, several American states established constitutional governments. In 1777, John Jay of New York helped write a constitution for his state. John Adams of Massachusetts helped write the Massachusetts Constitution of 1780. Delegates to the convention in Philadelphia used many ideas and words from the constitutions of this and other states. Delegates also benefited from their own experiences. For example, Franklin proposed at the Albany Convention in 1754 that the colonies be united under a central government. Washington recalled the problems he faced in the war when, as commander-in-chief, he had to work with the weak Confederate government. Almost every delegate at the convention had served as either a soldier or a civil servant. The delegates often disagreed on the details, but agreed that the new government should be strong enough to govern the country and at the same time not pose a threat to the liberties of the states and the people. Compromises. The task of creating a new government was not easily accomplished. Debates among delegates nearly brought the convention to an end on several occasions. For example, delegates from larger and more populous states disagreed with representatives from smaller states regarding representation in the national legislature. The large states were in favor of the Virginia Plan, which proposed that the number of delegates each state would send to the national legislature be determined according to its population ratio. Smaller states supported the New Jersey Plan, which proposed that all states have an equal number of representatives. Connecticut delegates proposed a compromise that resolved the issue. Their plan provided equal representation in the Senate and representation in the House of Representatives based on population ratio. This proposal became known as the Connecticut Compromise or the Great Compromise. The compromises also resolved disputes over slavery. Northern states' delegates wanted Congress to have the power to ban the foreign slave trade and, over time, abolish slavery. Most Southern delegates were against Congress having this power. A compromise ensured that Congress would not be allowed to regulate the foreign slave trade until 1808. Another compromise concerned the issue of how to count slaves in determining how many House members a state would elect. Slaves were not considered citizens, so the convention recognized that only 3/5 of them could be counted. The delegates agreed to convene a special convention in each state to discuss and vote on the Constitution. They also decided that as soon as the 9 states ratified the Constitution, it would go into effect and they could begin forming the new government. Approval of the Constitution. Less than 3 months after its signing, on December 7, 1787, Delaware became the first state to ratify the Constitution. New Hampshire became the 9th state to ratify the Constitution and took it into effect on June 21, 1788. However, the founders could not be sure of general acceptance of the Constitution until key states such as New York and Virginia had ratified it. A strong and organized opposition to the Constitution had formed in these 2 states and some other states. People such as Elbridge Gerry, Patrick Henry, Richard Henry Lee, and George Mason opposed the ratification of the Constitution. Critics objected that the Constitution lacked a Bill of Rights, that the President was too independent, and that the Senate was too aristocratic. They also felt that Congress had too much power and the national government had too much authority. Those who supported the Constitution tried to provide support for its ratification. They became known as the Federalists. Those who were against these were called Anti-Federalists. These 2 groups tried to spread their ideas through newspapers, brochures, and discussions at the conventions held to ratify the Constitution. These groups developed America's first political parties. Virginia ratified the Constitution on June 25, and New York ratified it on July 26, 1788. By early January 1789, all of the states that had ratified the Constitution, except New York, appointed electors who would elect the president, either in their own legislatures or by direct popular vote. New York was unable to meet its own voters by the agreed deadline for this process. On February 4, voters elected George Washington as the first President of the United States. In accordance with the Constitution, the first Congress convened in New York on March 4. Washington took office with an oath ceremony on April 30. But North Carolina and Rhode Island refused to ratify the Constitution and join the new administration until Congress agreed to add a Bill of Rights. Bill of Rights. If the Federalists had not promised to add a Bill of Rights to the Constitution, ratification by some key states might not have been possible. Most state constitutions adopted during the Revolutionary War era contained an express declaration of civil rights. Most Americans believed that no constitution could be considered complete without such a declaration. Virginian George Mason was responsible for America's first and most famous Bill of Rights, the Virginia Declaration of Rights of 1776. If the Federalists had not agreed to their demands for amendments, George Mason and Patrick Henry might have blocked the ratification of the Constitution in Virginia. James Madison took the lead in amending the Constitution in the new Congress. 12 of the 15 articles that he proposed to be changed were presented to the states by the Congress in accordance with the law change process specified in the 5th article of the Constitution. On December 15, 1791, 10 of the 12 amendments proposed were approved by a sufficient number of state legislatures to become permanent annexes to the Constitution. These 10 amended laws are known as the Bill of Rights. One of the 2 rejected amendments concerned the number of members of the House of Representatives. This amendment changed the clause of not having more than one representative for every 30,000 people to one representative for every 50,000 people. The other amendment that was rejected would have ensured that members of Congress could not change their salaries until after a representative election. This article, approved 202 years later, was the 27th Amendment to the Constitution. Once the Constitution was ratified, the Anti-Federalists admitted defeat and attempted to gain power within the terms of the Constitution. Their action began an unchanging tradition in American politics. Americans have sometimes felt dissatisfied with the policies and practices of their rulers. But few Americans condemned the constitutional system or felt that a new constitutional convention would do better. Development of the Constitution. James Madison said, "In drawing the framework of a system that we want to last for many years, we must not forget the changes that the years will bring." The Constitution was prepared to serve the interests of all people, rich and poor, northern and southern, farmers, workers and businessmen. Over the years, the Constitution has been interpreted to meet the changing needs of the United States. The delegates attending the Constitutional Convention believed strongly in majority rule, but they wanted to protect the minority against any injustice by the majority. They achieved this goal by separating management powers and establishing a balance between them. Other basic purposes of the Constitution include respect for the rights of individuals and states, government by the people, separation of church and state, and the supremacy of the national government. There have been 27 amendments to the Constitution so far, including the Bill of Rights. Amendments are recommended by either 2/3 of both houses of Congress, or by a national convention called by Congress at the request of the legislatures of 3/4 of the states. An amendment becomes a part of the Constitution after it has been approved by the legislatures of 3/4 of the states or by conventions of 3/4 of the states. Congress decides what type of ratification method to use and how long to give states to review each change. Generally, Congress gives states a 7-year period to consider changes. Delegates attending the Constitutional Convention knew that they could not make a law for every possible situation. Therefore, they gave Congress the right to make all laws necessary and proper to carry out the powers that the Constitution gave to the President, Congress, and the federal courts. Congress passed laws establishing administrative organizations such as the Federal Aviation Administration and the Postal Service. Additionally, Congress regulates interstate commerce in the U.S. He also passed many laws to control many aspects of the economy. Court decisions. Federal and state judges apply the Constitution in many cases. In any case, the Supreme Court has final authority to interpret the Constitution. The Supreme Court has the authority to examine whether the law complies with the Constitution. In other words, he may deem a law unconstitutional. This authority of the Supreme Court is based mostly on the decision given by Supreme Court Chief Justice John Marshall in 1803 in the Madison-Marbury case. Since then, the Supreme Court has ruled that more than 125 federal laws and hundreds of state laws are unconstitutional. Presidential decisions. Powerful presidents have used the simple words of the Second Amendment to expand the president's powers into a great source of power. Some of the presidents who did this were George Washington, Thomas Jefferson, Andrew Jackson, Abraham Lincoln, Theodore Roosevelt, Woodrow Wilson, Franklin D. Roosevelt, and George W. Bush. For example, Washington has enabled the president to assume a leadership role in foreign affairs. Lincoln used the powers specified in this article to free the slaves during the Civil War, 1861 to 1865. Traditions. It made the Constitution flexible and increased the powers of the national government. For example, the composition of the President's cabinet stems from the words in Article 2, which allows the President to request the principal officer in each department of the executive branch to express his opinion in writing on any matter relating to the functions of his department. State and party decisions. The Constitution establishes a general method for presidential elections. He does not mention political parties. But state laws and political party practices have transformed the constitutional electoral system into today's exciting election campaigns and elections. The Constitution has continued to evolve through all these methods to respond to the demands of an ever-growing society. However, the spirit and style of the Constitution have always remained the same. People of every generation have applied the articles of the Constitution to their problems in a way that makes sense to them. British statesman William E. Gladstone described the Constitution as, at a certain time he described it as the most marvelous work produced by human intelligence and purpose. In a world of change and struggle, the American people have no more valuable asset than this magnificent document. Below you can see the full text of the United States Constitution and its amendments. On the following pages, the same text is given along with explanatory information. United States Constitution. We, the people of the United States, do hereby ordain and establish this Constitution of the United States of America, in order to create a more perfect union, to establish justice, to secure domestic tranquility, to provide for the common defense, to promote the general welfare, and to secure the blessings of liberty to ourselves and our posterity. Article 1. Part 1. All legislative powers conferred by this Act shall be vested in the Congress of the United States, consisting of a Senate and a House of Representatives. Part 2. The House of Representatives shall consist of members elected every 2 years by the people of each state, and the electors of each state shall have the qualifications applicable to members of the most numerous house of the state legislature. No person may be a representative who has not attained the age of 25 years, who has not been a citizen of the United States for 7 years, and who has not been a resident of the state for which he is elected at the time of his election. Representatives and direct taxes shall be distributed among the states within this Union, according to their respective populations to all free persons, including those liable for service for a period of time, and excluding Indians, from whom no taxes shall be levied, to be determined by the addition of 3/5 of all other persons. The actual census shall be held within 3 years after the first session of the Congress of the United States, and every 10 years thereafter, as provided by law. The number of representatives shall not be more than 1 representative for every 30,000 people, but each state shall have at least 1 representative, and until such a census shall be made, the state of New Hampshire 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina will have the right to elect 5 representatives, and Georgia 3. In the event of vacancies in the representation of any state, the executive branch of the state shall order elections to fill such vacancies. The House of Representatives shall elect its president and other officers, and the power to impeach abuse of power shall rest solely with the House of Representatives. Part 3. The Senate of the United States shall consist of 2 members of the Senate, to be elected by each state legislature for 6 years, and each senator shall have 1 vote. Immediately after the first meetings following the primary election, the members of the Senate shall be divided into 3 groups as equally as possible. The seats of senators of the first group shall become vacant at the expiration of the second year, the seats of the second group shall become vacant at the expiration of 4 years, and the seats of the third group at the end of the 6th year, so that every 2 years 1/3 of the members shall be elected. If a vacancy becomes vacant while the legislature of any state is in recess, by resignation or otherwise, the executive branch of that state shall make a temporary appointment until the legislature meets and fill the vacancy when the legislature meets. No person may be a senator who has not attained the age of 30 years, who has not been a citizen of the United States for 9 years, and who, at the time of his election, has not been a resident of the state for which he was elected. The Vice President of the United States shall be President of the Senate, but shall have no vote unless the votes are equally distributed. The Senate shall appoint other officers and shall also elect a president pro tempore to succeed the vice president in his absence or while he is serving as president of the United States. The only authority authorized to try accused federal officials is the Senate. When assembled for this purpose, the members of the Senate shall either take an oath or make an unsworn declaration in lieu of an affidavit. When the President of the United States shall be tried, the Chief Justice of the Supreme Court shall preside over the session, and the guilt of no person shall be adjudged except by the decision of 2/3 of the members present. Judgment in cases of impeached federal officers shall amount to no more than removal from office and disqualification from holding any position of trust, honorary or paid position in the service of the United States, but the party found guilty may still be indicted, prosecuted, tried, and punished in accordance with the law. Part 4. The time, place, and manner of holding elections for members of the Senate and House of Representatives shall be determined in each state by the legislature of that state, but Congress may by law make or amend such rules except for the electing places of members of the Senate. The Congress shall meet at least once each year, and unless another day is fixed by law, this meeting shall be on the first Monday in December. Part 5. Each House shall have the power to decide on the election of its members, the results and nature of elections, and a majority in each House shall constitute a quorum to carry out its work, but a smaller number of members may adjourn the meeting from one day to another, and may have the power to compel those absent to attend, in such manner and under such penalties as each assembly may approve. Each chamber may make its own rules of procedure, punish its members for disruptive behavior, and decide, by a 2/3 majority, to expel a member. Each assembly shall keep the minutes of its deliberations, and shall publish them from time to time, except such parts as it may think fit to remain secret, and the votes of the members of both houses, for or against any matter, shall be recorded in the minutes upon the request of 1/5 of the members present. While the Congress is in session, neither house shall adjourn its deliberations for more than 3 days without the consent of the other, and shall not meet at any place other than the place where both houses meet. Part 6. Members of the Senate and the House of Representatives shall receive, for their services, an allowance fixed by law and paid by the Treasury of the United States. Members shall not be arrested in any way while attending or traveling to meetings of their own assembly, except for treason against the state, serious crime, and violation of public security, and they will not be questioned anywhere else other than that assembly for their speeches and discussions in any of the assemblies. No member of the Senate or House of Representatives shall, during the term of office for which he has been elected, be appointed to any civil office under the authority of the United States, which shall be established or whose compensation shall be increased during such term, and any person holding the office of a civil servant in the United States shall not be a member of either house while holding such office. Part 7. All bills aimed at increasing revenues will be prepared in the House of Representatives, but the Senate may propose amendments or accept the bills as is, as with other bills. Every bill passed by the House of Representatives and the Senate, before becoming a law, shall be submitted to the President of the United States. If the President considers it appropriate, he will sign it, but if he does not consider it appropriate, he will send it back to the Parliament from which it originated, together with his objections. This assembly will generally record the objections and reconsider the bill. If, at the end of the renegotiation, the bill is accepted by 2/3 of that chamber, the bill will be sent to the other chamber for reconsideration along with the objections. The bill will become law when it is accepted by 2/3 of this Parliament. However, in all such cases, the votes in both chambers will be determined as yes or no, and the names of those in favor and against the bill will be recorded in the minutes of both chambers. If the President does not return a bill to the House within 10 days, excluding Sundays, after its introduction, the bill will become law as if it had been signed by the President, but it will not become law if Congress goes into recess, preventing its return. Every order, resolution, or vote requiring the concurrence of the Senate and the House of Representatives, except with respect to terminating the term, shall be submitted to the President of the United States and shall, before taking effect, be approved by the President, or, in the case of the President's disapproval, shall be applied to bills. Shall be readopted by 2/3 of the Senate and the House of Representatives, in accordance with the rules and limitations. Part 8. Congress shall have the following powers: to lay down and collect taxes, duties, customs, excise, and excise duties, to pay the public debts, and to provide for the common defense and general welfare of the United States, but the same customs, manufacturing, and excise duties shall be imposed throughout the United States. Borrow money on behalf of the United States. To regulate commerce with foreign countries and among the many states and with Native American tribes. To impose throughout the United States one rule for naturalization, and one law for bankruptcies, which shall apply to all states. To coin coins and regulate the value thereof, as well as the value of foreign currencies, and to establish standards of weights and measures. To ensure the punishment of those who counterfeit the securities and coinage of the United States. Establishing post offices and mail routes. To promote the development of science and useful arts by granting to authors and inventors, for a limited time, the exclusive right to their writings and inventions. Creating courts smaller than the Supreme Court. To define and punish piracy, serious crimes committed on the high seas and acts contrary to international law. To declare war. To issue letters of authorization to use armed ships and to respond, and to establish rules regarding seizures on land and in water. Forming and feeding armies, provided, however, that the appropriation of money for such use shall not be valid for more than 2 years. Establishing and maintaining a naval power. To make regulations for the administration and organization of land and naval forces. To ensure that militia forces are called to duty to enforce the laws of the Union, suppress rebellions, and repel invasions. To provide command to that portion of the militia to be employed in the service of the United States, with the power to organize, equip, and discipline the militia, to appoint officers, and to train the militia in accordance with the rules prescribed by Congress, to be reserved to the states. To exercise special legislative authority in all matters within the territory, not to exceed 10 square miles, which shall be the capital of the United States government upon the waiver of certain states and the consent of the Congress, and to erect, with the consent of the state legislature, the forts, ammunition depots, military ordnance depots, shipyards, and other buildings constructed in that state. Have the same authority over the places purchased for the necessary buildings, and to make all laws necessary and proper to carry out the powers hereinbefore stated, and all other powers conferred by this Constitution upon the government of the United States, or upon any department or officer thereof. Part 9. The Congress shall not prohibit the emigration or introduction into the country of such persons as any of the existing states shall find fit to admit, before the year 1880, but a tax or duty not exceeding $10 per head may be levied on such persons so brought into the country. The privilege of habeas corpus writ shall not be suspended in cases of rebellion or invasion, unless the public safety may require it. No law or retroactive law regarding the acquisition of citizenship rights will be enacted. No head tax or other direct tax shall be levied except in proportion to the census as expressly stated above. No taxes or duties will be collected on goods exported from any of the states. There will be no preference given between state ports as a matter of trade regulation or revenue. Ships entering or leaving a state will not have to enter the port of another state, unload their cargo, or pay customs. No money shall be withdrawn from the Treasury except as authorized by law for expenditure, and a regular report of public revenues and expenditures shall be published from time to time. No title of nobility shall be conferred by the United States, and no person holding any official or honorary office shall in any manner accept, without the consent of Congress, any gift, consideration of money, office, or title, from any king, prince, or foreign power. Will not. Part 10. The states shall not enter into any treaty, alliance, or confederation, will not give permission to attack enemy ships, will not issue bills that can be used like money, he will offer nothing but gold and silver coins to pay the debt, it shall not decide to punish without trial or confiscate all the property of the prisoner for serious crimes or treason, nor shall it enact any retroactive law or revoke the binding force of contracts, or grant any title of nobility. No state shall, without the consent of Congress, impose any tax or duty upon imports or exports, except such as shall be strictly necessary to enforce its control laws, and the net amount of all taxes and duties which any state may impose on imports or exports shall be vested in the Treasury of the United States, and all such laws shall be subject to the scrutiny and control of Congress. No state shall, without the consent of Congress, levy a tonnage tax, maintain troops or warships in time of peace, enter into any treaty or compact with another state or a foreign state, or engage in war unless actually occupied or so imminent danger as to admit of a delay. Will not enter. Article 2. Part 1. Executive power shall be vested in the President of the United States. He shall hold this office for a term of 4 years, with the Vice President elected for the same term, elected as follows. Each state shall appoint a number of electors equal to the total number of members of the Senate and House of Representatives to whom that state has the right to refer to Congress, as the state legislature shall appoint, but no member of the Senate or House of Representatives, or any person holding any official or honorary office on behalf of the United States, shall be appointed elector. Electors will gather in their own state and elect 2 people, at least one of whom does not reside in the same state, by secret ballot. They shall make a list of all persons voted and the votes received by each. They will sign and approve this list and send it in a sealed envelope from the headquarters of the United States to the President of the Senate. The President of the Senate, in the presence of the Senate and the House of Representatives, will open all documents and then the votes will be counted. The person with the greatest number of votes shall be president if his votes constitute a majority of all appointed electors. If more than one person have such a majority, and their votes are equal, then the House of Representatives shall immediately by secret ballot elect one of them president. If none obtains a majority, the House of Representatives shall likewise elect a president from among the 5 persons who have received the greatest number of votes on the list. However, in the election of the president, votes will be given by state, and each state representative will have 1 vote. For this purpose, a quorum consisting of the representative or representatives of 2/3 of the states is required, and a majority of all states must be present for the election. In all cases, following the election of president, the person with the second highest number of votes from the electors will be the vice president. But when there are 2 or more persons having an equal number of votes, the Senate shall, by secret ballot, elect one of them to be vice president. The Congress may fix the date on which the members of the Electoral College will be elected and the day on which they will vote. This day will be the same for all of the United States. No person shall be eligible for election to the presidency except such persons as are citizens of the United States by birth, or at the time of the adoption of this Constitution. A person who has not reached the age of 35 and who has not resided in the United States for 14 years is also ineligible to run for office. In the event of the removal, death, resignation, or incapacity of the President to discharge the powers and functions of his office, such powers and functions shall pass to the Vice President, and in the event of the removal, death, resignation, or incapacity of both the President and the Vice President, the Congress shall, by law, shall declare which officer shall serve as President, and this person shall serve as President until the incapacity is eliminated or a President is elected. The President shall receive from time to time, in return for his services, an emolument which shall neither be increased nor diminished during the term of office for which he has been elected, and shall not receive any other emolument from the United States or any state during such period. Before taking office, the President shall take the oath or promise as follows. I do solemnly swear, promise, upon my honor to faithfully discharge the office of President of the United States and to uphold, protect, and defend the Constitution of the United States to the best of my ability. Part 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militias of the states when called to active service for the United States. It shall have the authority to request in writing the opinion of the chief officer of each department of the executive branch on any matter pertaining to the functions of his department, and shall have the authority to postpone the execution of and grant pardons for crimes against the United States, except in cases of abuse of power. The President shall have power to make treaties with the advice and consent of the Senate, and with the consent of 2/3 of the senators present, and shall, with the advice and consent of the Senate, appoint ambassadors, other diplomatic persons and consuls, judges of the Supreme Court, and all officers for offices of the United States not provided for in this Constitution, which shall be established by law, but the Congress shall, by law, appoint such inferior officers as it may think fit. Can only be given to the President, the courts or the heads of executive departments. The President shall have the authority to appoint to all positions vacant during the recess of the Senate, to expire at the end of the following term of the Senate. Part 3. The President shall, from time to time, inform the Congress of the state of the Union, and submit to their consideration such measures as he may deem necessary and expedient. In cases of emergency, he may call both houses, or either house, into session, and in case of disagreement between them as to the recess, at such time as he may think fit, will be able to give them a holiday, shall receive ambassadors and other representatives of foreign states, shall see to the faithful execution of the laws, and shall appoint all officers of the United States. Part 4. The President, the Vice President, and all civil officers of the United States shall be removed from office if charged with and convicted of treason, bribery, other high crimes, or malfeasance. Article 3. Part 1. The judicial power of the United States shall be vested in a Supreme Court, and in such subordinate courts as the Congress shall from time to time appoint and establish. Judges of the Supreme Court and lower courts shall remain in office during their good behavior, and shall receive a non-decreasable salary for their services at fixed times while in office. Part 2. The jurisdiction of the judicial branch shall include all civil and judicial cases arising under this Constitution, all cases arising from the laws of the United States and the treaties made or to be made under the authority thereof, and all cases falling within the scope of laws and precedents, all cases involving ambassadors, other diplomatic officers and consuls, all maritime law and maritime cases, disputes in which the United States will be a party, disputes between two or more states, disputes between citizens of one state and another state. It shall include disputes between citizens of the same state claiming land grants from different states, and disputes between a state or citizens of that state and foreign states' citizens or foreign nationals. The Supreme Court shall have primary jurisdiction over all cases involving ambassadors, representatives, and consuls of other foreign states and to which a state is a party. In all other cases previously enumerated, the Supreme Court shall have appellate jurisdiction, both in law and in fact, within the exceptions which Congress shall make and the rules which it shall make. Except for malfeasance, all crimes shall be tried by jury, and such trial shall be held in the state in which those crimes were committed, but if the crime is not committed within the borders of any of the states, the trial shall be held in such place or places as Congress may by law prescribe. Part 3. Treason against the United States shall include waging war against the United States alone or siding with the enemies of the United States by providing aid. No one shall be found guilty of treason unless on the testimony of two persons who saw him in flagranti delicto, or unless he confesses in open court. Congress will have the authority to determine the punishment for the crime of treason, but a conviction for treason will not apply to family members, and the property of a person convicted of treason will not be confiscated beyond his lifetime. Article 4. Part 1. Each state shall give full confidence to and comply with the laws, records, and procedures of all other states. Congress shall by general laws prescribe the manner in which such laws, records, and proceedings shall be evidenced, and their scope. Part 2. The citizens of each state shall have all the privileges and immunities of citizens of the other states. If a person accused of treason, a high crime, or any other crime, in any state, escapes from justice and is apprehended in another state, he shall, at the request of the executive authority of the state from which he fled, be delivered to the state having jurisdiction of the crime. When a person, under the laws of a state, performs compulsory service or work in that state, flees to another state, he shall not be excused from such service or work as a result of any law or rule in that state, but shall be reinstated at the request of the party who will perform such service or work. Part 3. New states may be admitted into this Union by Congress, but no new state may be established within the jurisdiction of a state. A state cannot be created by the union of two or more states or parts of states without the consent of Congress or the relevant state legislatures. The Congress shall have the power to use the territory or property of the United States, and to make all necessary rules and regulations respecting the same, and nothing in this Constitution shall be construed to prejudice the rights of the United States, or of any particular state. Part 4. The United States shall guarantee a republican form of government to every state in this Union, and shall invade each of them, and will protect against internal attacks by application of the legislature or, when the legislature cannot meet, the executive branch. Article 5. The Congress may, when a two-thirds majority of both houses shall deem necessary, propose amendments to this Constitution, or call in convention to propose amendments upon the application of the legislatures of two-thirds of the states. In either case, the amendments, if ratified by the legislatures of three-fourths of the states, or by conventions of three-fourths of the states, either of which ratification may be proposed by Congress, shall in all respects and matters be a part of this Constitution and shall be deemed valid. However, before the year 1800, no amendment shall in any way affect the first and fourth paragraphs of the 9th section of the first article, and no state shall be deprived of an equal vote in the Senate without its consent. Article 6. All debt agreements made and obligations entered into before the adoption of this Constitution are valid for the United States under this Constitution, as well as for the Confederacy. This Constitution and the laws of the United States made pursuant thereto, and all treaties made, or to be made, under the authority of the United States, shall be the supreme law of the land, and the judges in all states shall observe this superior law, notwithstanding any contrary provision in the Constitution or laws of any state. The members of the Senate and the House of Representatives aforesaid, and the members of the legislatures of the states, and the officers of the executive and judicial branches of the United States and of the states, shall swear or pledge to abide by this Constitution, but a religious test shall not be required as a qualifying measure for any office or public service in the United States. Article 7. Ratification by 9 state conventions shall be sufficient to bring this Constitution into force among the ratifying states. Adopted unanimously at the meeting of the participating states, on the 17th day of September of the Gregorian year, 1787, and on the 12th anniversary of the independence of the United States of America. We wrote our names as witnesses of this. George Washington, President and Representative from Virginia. Amendments to the United States Constitution. Bill of Rights, Amendments 1 to 10. Preamble to the Bill of Rights. United States Congress. It began and took place in New York City on Wednesday, the 4th of March, 1789. Some of the state conventions, when adopting the Constitution, stated that they wanted explanatory and restrictive clauses to be added in order to prevent possible misinterpretations of the Constitution or abuse of the powers it provides. Thus, the basis of public trust in the state will be expanded and the most perfect benefit from the constitutional institution will be ensured. That the Senate and the House of Representatives of the United States of America, sitting in Congress, by a two-thirds vote in favor of both houses, propose to the state legislatures the following articles as amendments to the Constitution of the United States. It is resolved that if all or any of these articles are approved by 3/4 of the above-mentioned legislative bodies, they shall become a part of the above-mentioned Constitution in all respects and matters and shall be deemed valid. Articles supplementing and amending the Constitution of the United States, proposed by Congress and ratified by the legislatures of the states, pursuant to Article 5 of the original Constitution. Amendment 1. Congress, relating to a religious institution or prohibiting free worship, or restricts freedom of expression or freedom of the press, or make any law abridging the right of the people peacefully to assemble and to petition the government for a remedy of any grievance. Amendment 2. A regular militia being indispensable to the security of a free state, the right of the people to keep and bear arms shall not be violated. Amendment 3. No soldier can fight in peacetime without the consent of his owner. In time of war, they will not be placed in a house without complying with the procedure determined by the law. Amendment 4. The immunity of persons against unnecessary searches and seizures of their persons, houses, documents, and belongings shall not be violated, and the warrant granting this authority shall be based on probable cause, shall be supported by oath and declaration, and shall particularly specify the place to be searched, the person to be arrested and the goods to be seized. Amendment 5. Except in cases arising in the land or naval forces, or in the militia on duty in time of war or public threat, no person shall be held responsible for a capital crime or any other infamous crime, without a criminal complaint or indictment prepared by a grand jury. No one shall be subjected to the death penalty or the risk of losing an organ twice for the same crime, shall not be compelled to testify against himself in any criminal case, and shall not be deprived of life, liberty, or property. Without satisfying the legal requirements, private property cannot be expropriated without paying fair compensation. Amendment 6. In all criminal cases, the accused shall have a speedy and public trial by an impartial jury of the state in which the crime was committed and of the district previously determined by law, and shall be informed of the nature and cause of the accusation, confronting witnesses against himself. He shall have the right to bring witnesses into court to provide evidence in his favor, and to retain counsel for his defense. Amendment 7. In common law cases where the amount in dispute exceeds $20, the right to trial by a jury shall be reserved, and a matter tried by jury shall not be retried in any court of the United States, except under the rules of the common law. Amendment 8. Too high bail will not be required, excessive fines will not be imposed, and cruel and unusual punishments will not be imposed. Amendment 9. The fact that some rights are listed in the Constitution will not be interpreted as denying or belittling other rights of the people. Amendment 10. Any powers not delegated to the United States by the Constitution, nor prohibited by the Constitution to the states, are reserved to the states, or to the people. Amendment 11. 1795. The jurisdiction of the United States shall not be construed to extend to any action in law or equity brought or pending against a state of the United States by citizens of another state, or by citizens or aliens of a foreign state. Amendment 12, 1804. Electors shall meet in their respective states and elect, by secret ballot, a president and a vice president, at least one of whom is not a resident of the same state as themselves. They shall state on the ballot papers whom they have chosen to be president, and on separate ballots whom they have elected to be vice president, and shall make 2 separate lists showing the names of all persons voted for president, the names of all persons voted for vice president, and the number of votes received by each of them, and these lists shall be signed and certified, shall send it in a sealed envelope to the President of the Senate at the seat of the United States government. The President of the Senate, in the presence of the Senate and the House of Representatives, will open all documents and then the votes will be counted. The person receiving the greatest number of votes for the presidency shall be president if such number constitutes a majority of all appointed electors, if no one has such a majority. Then the House of Representatives shall immediately elect the president, by secret ballot, from among those named in the list of candidates for the presidency, having the highest number of votes, not exceeding 3 persons. But in electing a president, the votes shall be cast by state, and each state representative shall have 1 vote. A quorum of representatives or representatives of 2/3 of the states is required for this purpose, and a majority of all the states must be present for the election. And if the House of Representatives shall not elect the President before the 4th day of March next, when the right to elect the President shall have passed to the House of Representatives, then the President the Vice President shall assume the office of President in the same manner as in the event of the President's death or other constitutional incapacity*. Amended by Section 3 of the 20th Amendment. The person who shall receive the greatest number of votes for Vice President shall, if such number constitute a majority of the whole number of electors appointed, be the Vice President, and if no person shall have such majority, then the Senate shall elect for Vice President one of the 2 persons who shall have the greatest number of votes on the list. A quorum for this purpose shall consist of 2/3 of the total number of members of the Senate, and a majority of the total number shall be required for election. However, a person whom the Constitution does not consider qualified for the presidency will not be qualified for the Vice President of the United States. Amendment 13, 1865. Part 1. Neither slavery nor forced labor shall be practiced in the United States or any place under the jurisdiction of the United States, except upon punishment of the rightfully convicted. Part 2. Congress shall have the authority to enforce this article by appropriate legislation. Amendment 14, 1868. Part 1. All persons born or naturalized in the United States and subject to the jurisdiction of the United States are citizens of the United States and of the state in which they reside. No state shall make or enforce any law abridging the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, or exclude any person within its jurisdiction from the equal protection of the laws. Part 2. The membership in the House of Representatives shall be apportioned among the states in proportion to the entire enumerated population of each state except Indians, who shall not be taxed. However, men who are 21 years of age and citizens of the United States, residing in a state, may elect electors to elect the President and Vice President, members of Congress, officers of the executive or judicial branches of a state, or members of the legislature of that state, except for participation in insurrection or any other crime. If the right to vote is deprived or abridged in an election for the state, the number of representatives of this state shall be reduced by the proportion of the number of such males in proportion to the total number of males in this state who are 21 years of age. Amended by Section 1 of the 26th Amendment. Part 3. Participates in rebellion or insurrection against the United States, as a member of Congress, United States officer, or member of a state legislature, state executive, or judicial branch, or who gives aid to the enemies of the United States, shall not be a member of the Congress, of the Senate or of the House of Representatives, or a selectman in the election of President or Vice President, nor shall he hold any office, civil or military, in the United States or in any state. However, Congress can remove such incapacity by a decision taken by a two-thirds majority in both chambers. Part 4. The validity of public debts lawfully incurred by the United States, including debts incurred to pay salaries and bonuses for services in suppressing insurrections or insurrections, will not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation made in aid of insurrection or insurrection against the United States, or any claim for compensation for the loss or emancipation of a slave. All such debts, commitments, and claims for compensation shall be deemed illegal and void. Part 5. Congress shall have the authority to enforce the provisions of this article by appropriate legislation. Amendment 15, 1870. Part 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or former servitude. Part 2. Congress shall have the authority to enforce this article by appropriate legislation. Amendment 16, 1913. Congress shall have power to levy and collect taxes on all revenues, from whatever source derived, without apportionment among the states, and without regard to any census or calculation. Amendment 17, 1913. The Senate of the United States shall consist of 2 senators in each state, elected by the people of that state for a term of 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications required of electors of the most numerous House of State Legislatures. In the event of a vacancy in the representatives of a state in the Senate, the executive authority of such state shall order elections to fill such vacancies, provided, however, that until the people of that state shall fill the vacancies by such election as may be prescribed by law, the state legislature shall authorize the state executive to order such vacancies temporarily. May grant the authority to make appointments. This amendment, as a part of the Constitution, should not be construed as affecting the election or term of office of a member of the Senate elected prior to its enactment. Amendment 18, 1919, repealed by the 21st Amendment. Part 1. Beginning with the expiration of 1 year following the ratification of this article, the manufacture, sale, or transportation within the United States of intoxicating liquors for the purpose of consumption, or the importation into or exportation of intoxicating liquors from the United States and all territories subject to its jurisdiction, is prohibited. Part 2. Congress and the states shall have complementary authority to enforce this provision by appropriate legislation. Part 3. This article shall be void unless ratified by the state legislatures and become a part of the Constitution, as provided in the Constitution, within 7 years after its submission by Congress to the states. Amendment 19, 1920. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. Amendment 20, 1933. Part 1. The terms of office of the President and Vice President shall expire at noon on the 20th day of January in the year in which their terms would have expired had this article not been ratified, and those of the members of the Senate and the House of Representatives shall expire at noon on the 3rd day of January in the year in which their terms would have expired had this article not been ratified, and the terms of office of those elected in their place will begin at that time. Part 2. The Congress will meet at least once every year, and unless another day is determined by law, this meeting will begin at noon on the 3rd day of January. Part 3. If the newly elected President dies on the date fixed for the commencement of the President's term, the newly elected Vice President shall become President. If the President is not elected before the date fixed for the commencement of his term, or if the newly elected President is not qualified, the newly elected Vice President shall serve as President until the President becomes qualified, and in case both the President and Vice President-elect are not qualified, the Congress shall by law determine who shall assume the presidency, or the manner in which such person shall be appointed to assume the office, and such person shall hold the office until the President or Vice President shall be qualified. Part 4. In the event of the death of one of the persons from among whom the House of Representatives may elect President when the duty falls upon it, and the Congress may by law prescribe the manner of action in the event of the death of any of the persons from among whom the Senate may elect a Vice President when the office is entrusted to him. Part 5. Parts 1 and 2 will enter into force on the 15th of October following the approval of this article. Part 6. This article shall be null and void unless it is approved as an amendment to the Constitution by the legislatures of 3/4 of the states within 7 years from the date of its submission for ratification. Amendment 21, 1933. Part 1. The 18th Amendment to the United States Constitution has been repealed. Part 2. It is prohibited to transport or import intoxicating liquors into or for distribution or use in any state, territory, or jurisdiction of the United States, in violation of the laws of such state, territory, or jurisdiction. Part 3. This article shall be void unless ratified as a constitutional amendment by the state conventions within 7 years from the date of its submission to the states by Congress, as provided by the Constitution. Amendment 22, 1951. Part 1. No person shall be elected to the office of President more than twice, and a person who has undertaken the responsibility of the presidency, or has deputized for more than 2 years of the term of office of another person previously elected to the presidency, shall not be elected president more than once. However, this article will not apply to the person who assumed the office of president when it was proposed to the Congress, and it will not prevent the person who occupies the office of the President or deputizes him during the period for this article to become effective, from continuing to hold the office of President or deputizing for him for the remainder of this period. Part 2. This article shall be null and void unless it is approved as an amendment to the Constitution by the legislatures of 3/4 of the states within 7 years from its submission to the states by Congress. Amendment 23, 1961. Part 1. The territory, which forms the seat of the government of the United States, shall, as Congress directs. For the election of President and Vice President, the state shall appoint a number of electors equal to the number of members of the Senate and House of Representatives that would be required for its representation in Congress if it were a state, but in no case greater than that of the least populous state. These shall be in addition to those appointed by the states, but, in the election of the President and Vice President, shall be deemed to be appointed by a state, and they shall gather in the district and perform the duties prescribed by the 12th Amendment. Part 2. Congress shall have authority to enforce this article by appropriate legislation. Amendment 24, 1964. Part 1. In a primary or other election for President or Vice President, the right of citizens of the United States to vote in the election of members of the Electoral College for President or Vice President, or of members of the Senate and House of Representatives of Congress, shall not be denied or abridged by the United States or by any state for non-payment of any poll or other tax. Part 2. Congress shall have power to enforce this article by appropriate legislation. Amendment 25, 1967. Part 1. In the event of the removal, death, or resignation of the President, the Vice President shall become President. Part 2. When there is a vacancy in the office of Vice President, the President shall appoint a Vice President who shall be confirmed by a majority vote of both houses of Congress and shall assume office. Part 3. When the President notifies in writing to the President pro tempore of the Senate and the Speaker of the House of Representatives that he is unable to discharge the powers and duties of his office, and until he notifies them in writing to the contrary, such powers and duties shall be exercised by the Vice President on behalf of the President. Part 4. When the Vice President and a majority of the principal officers of the executive branch or of any other agency designated by law by Congress shall notify the President pro tempore of the Senate and the Speaker of the House of Representatives in writing that the President is unable to discharge the powers and duties of that office, the Vice President shall immediately assume the powers and duties of that office by acting to the President. Will undertake their duties. Thereafter, when the President notifies in writing to the President pro tempore of the Senate and the Speaker of the House of Representatives that he is no longer incapacitated, the Vice President and a majority of the principal officers of the executive branch or of any other agency designated by Congress by law shall declare the President unfit to discharge his powers and duties for 4 days. Unless notified in writing, the President will reassume his powers and duties. When such a situation occurs, the Congress will decide on this matter, and if it is in recess, it will meet and decide on this issue within 48 hours at the latest. If the Congress determines, by a 2/3 majority of both houses, within 21 days after the delivery of the second instrument, or, if not in session, within 21 days from the date on which it is supposed to meet, that the President is unable to discharge the powers and duties, the Vice President shall become acting President. Shall assume powers and duties, otherwise, the President will reassume his duties and powers. Amendment 26, 1971. Part 1. The right of citizens of the United States to vote, 18 years of age or older, shall not be denied or abridged on account of age in the United States or in any state. Part 2. Congress shall have the authority to enforce this article by appropriate legislation. Amendment 27, 1992. No law changing the salaries of senators and members of the House of Representatives may be implemented until a new election of representatives has been held in the interim. For more, don't forget to subscribe to our channel and turn on notifications, like the video and recommend it to your friends, and share your ideas and suggestions in the comments. Hoping for a more just world. Goodbye.